Mirga and Samin, and the Secretary of State for Work and Pensions.
These are two appeals, each brought by a national of an EU country who claims to be entitled to financial or housing assistance in the UK. Ms. Mirga is a Pole who has lived in the UK since 2004. After leaving school, she worked for a few months, during which she became pregnant. She then claimed income support, which was refused. That decision was confirmed by the upper tribunal and the Court of Appeal. This was because she did not have the right of residence in the UK, as she had not worked in the UK for 12 months, as required by UK regulations following the 2003 treaty under which Poland joined the EU. Mr. Samin is an Austrian, though he was originally Iraqi. He came to the UK in 2004 when he did a few months' work. He has been unemployed since 2006 and has not been looking for work since 2007 because he suffers from poor mental and physical health. Having previously lived in private rented accommodation, in 2010 he sought accommodation from the local housing authority on the ground that he was homeless, but it was refused. This was because he did not have the right of residence in the UK under the immigration regulations made pursuant to a 2004 EU directive, as he had not done 12-month work in the UK. This decision was upheld by the County Court and the Court of Appeal. Ms. Mirga and Mr. Samin now each appeal to the Supreme Court and raise two arguments. The first argument rests on the Treaty on the Functioning of the European Union, the TFEU. Ms. Mirga contends that given the respect to be accorded to her family and private life under Article 8 of the European Convention on Human Rights, she could not be removed from the UK, and accordingly her right of residence under Article 21.1 of the TFEU could not lawfully be cut back by restricting her right to income support. Mr. Samin argued under this first head that refusal of housing assistance to him constituted unlawful discrimination contrary to Article 18.1 of the TFEU, because such assistance would have been accorded to a citizen of the UK or a qualifying member from another member state who was in the same position as Mr. Samin. As to the second argument, Ms. Mirga argued that in any event it would be only lawful to refuse her income support if it could be shown that to do so would be disproportionate. In other words, that it would place an unreasonable burden on the UK social assistance system to provide her with such support, and that there had been no inquiry into that issue. Mr. Samin's second argument was that the refusal of housing assistance could only be justified if it could be shown that the grant of such assistance would be disproportionate, and again, there had been no inquiry into that question. Today, the Supreme Court unanimously rejects these arguments and dismisses both Ms. Mirga's and Mr. Samin's appeal for reasons set out in a judgment given by me, with which Lady Hale, Lord Kerr, Lord Clark and Lord Reid agree. As to the first argument, the right accorded to Ms. Mirga by Article 21.1 of the TFEU is qualified by the words subject to the limitations and conditions laid down in the treaties and by the measures adopted to give them effect. In the present case, those measures include the 2003 accession treaty and the 2004 directive, and therefore the UK regulations made thereunder. A significant aim of these measures was to ensure that EU nationals from one member state should not be able to exercise rights of residence in another member state so as to become an unreasonable burden on the social assistance system. Accordingly, Article 21.1 of TFEU cannot assist Ms. Mirga. The Article 18 right claimed by Mr. Samin is limited to the scope of the treaties, which means that it only comes into play where there is discrimination in connection with the right in the TFEU or another EU treaty. Further, the right is without prejudice to any special provisions contained in the treaties, and therefore Mr. Samin's argument fails for the same reasons as Ms. Mirga's. The second argument that they raise, namely the determinations of the courts and tribunals below in relation to their claims were flawed because no consideration was given to the proportionality of refusing each of them social assistance is not supported by the decisions of the European Court of Justice upon which they rely. Indeed, it is inconsistent with two recent decisions of that court, Dano and Job Centre Leipzig, and Job Centre Berlin and Alimanovich. In any event, it is unrealistic to require an individual examination of each particular case. Where a national of another member state is not within the class of people protected by the 2004 directive, a worker, self-employed or a student, and has no or very limited means of support and no medical insurance, it would undermine the whole thrust of that directive if proportionality could be invoked in each case to entitle that person to have the right of residence and social assistance in another member state, save perhaps in extreme circumstances. Accordingly, both appeals are dismissed.